start thinking about your franchise agreement until you've got to the point that you've completed whatever research and due diligence you want to do in relation to your franchisor to ascertain that they are the people that you want to move forward with. So I would say getting your legal agreement looked at is probably something that you'll want to do after you've done all of your other research, basically. What I'm just going to cover on for a few minutes is what you should expect your franchise agreement to look like so that you don't have huge surprises when you receive it, and some top tips really for how to deal with it. So the first thing that you will probably find when you look at your franchise agreement for the first time is that it's very long, it's very one-sided, and it's one-sided in favour of the franchisor, not in favour of you as franchisees. And it's very, very tough. And it's tough for a reason, and there is a positive you can take from it, because you want your franchisor to take action to protect the brand that you're investing in. You want to know that if there are franchisees who are not performing properly and who are doing things that damage the reputation of the brand, that your franchisor will take action to terminate the franchise agreement if it's necessary. So the fact that it's a tough agreement is not necessarily something to be very frightened of. But the first time you get presented with that agreement, it can look quite daunting. So I'm saying this with a view to you not being too panicked as and when you actually get to see it. It's normally about 40 pages long, some of them longer, some of them are shorter, but it's quite detailed, and if you're not used to entering into commercial agreements, it can come as a little bit of a shock. One thing that you do have to bear in mind in relation to franchising, if you're investing in a franchise, you're doing it on a business-to-business basis. In other words, you as a business person are entering into another business agreement, into an agreement with another business owner. It is not a consumer contract, and therefore, unfortunately, all of the kinds of protections that tend to apply if you're buying a washing machine from John Lewis or something like that, they do not apply to you. You will be bound by the terms that you've signed up to. So understanding what is in your agreement is absolutely critically important. The franchise agreement sounds like an obvious point, doesn't it? The first thing it should make clear to you is who the identity of your franchisor is. So in other words, what corporate legal structure is entering into a contract with you. And you're going to want to make sure, or get your legal advisors to make sure, that they own the trademark that they are making the subject of the franchise. So in other words, what often happens is you enter into a franchise agreement, the trading name for the business is whatever it is, there is a trademark that's registered for it, but oh, guess what? It's not the franchisor in your agreement that owns that trademark. Now, sometimes there can be some reasons for that can be fairly easily resolved, but sometimes not. And I would say it's very important, at the end of the day, you are paying money for your franchise, and at its heart, the franchise agreement is a trademark license. So the trademark is quite critical, so do make sure that you get your lawyers to check that out for you. Obviously, the agreement is going to set out the term, in other words, how long it runs for, and it's going to set out what renewal rights you have. Now, the British Franchise Association are quite keen on franchisees having the right to renew their franchise agreement, and that's for a good reason. It's because ideally what the BFA wants is for you to have a business that you can realise some value on if you sell it down the line. So you're investing money, you hope you're going to make a return. Having a term of an agreement and then a right to renew is quite important in terms of enabling you to maximise the potential return that you can get on your investment. Quite a lot of what's taken up in your franchise agreement is going to relate to operating requirements. There'll be quite big chunks setting out in very detailed fashion the do's and don'ts of running that specific franchise. That will vary very much from one franchise to another, because there's no two businesses are the same, so no two franchise agreements are going to be the same. The operating requirements are going to sit alongside your operations manual. You won't get to see the operations manual in all likelihood until after you've signed the agreement, because the franchisor's got to protect the intellectual property and they've got to protect their confidentiality. So your operating requirements in the agreement will be linked to the operations manual, but they'll be more detailed. Another thing you're likely to get in the franchise agreement is some minimum performance criteria. These you must take seriously, because this is where the franchisor is saying to you, if you don't achieve sales at a certain level, or you don't achieve an output at a certain level during any particular year in the franchise, that the franchisor will reserve the right ultimately to terminate your franchise. You will not get your money back, and the minimum performance criteria are not just aspirational, they are contractual. So if you don't want to jeopardize the potential value and your potential investment in the franchise, make sure that you understand what the minimum performance criteria actually are. The BFA often encourage franchisors to ensure that the minimum performance criteria are fair, and in other words, therefore, they often go for a provision that says that the minimum performance criteria can't be more stringent than expecting the franchisee to achieve 70% of the average of what all other franchisees are achieving at any one time. So that does appear quite commonly, but minimum performance criteria do vary greatly. One other thing I haven't put on here that you also ought to anticipate, territory. And when you're around talking to potential franchisors, it's an important question to remember to ask, is there an exclusive territory that comes with the franchise? A lot of them have an exclusive territory, but they don't all. Some of them, and some of them are very successful franchise models, don't grant exclusivity on a territory basis because they have worked out that there is enough business to be done by the number of franchisees that they have on maybe a national level without it being necessary to divide the territory, to divide the country up into territories. So do make sure that you understand that. Franchise resales. Now this is all about selling your franchise. In an ideal world, as I said earlier, you want to ensure that you can recoup not just the value of your investment, but more than. And that if you've been running a business successfully and you've achieved a good turnover and a good level of profitability, that should, in principle, be a marketable asset to you. You should be in a position where you can sell the business at some stage down the line if all is going well. So your ability to sell your franchise is very important, and you do need to check that your franchise agreement does not have unfair controls. A franchisor will typically say that you can sell your business, provided that they can approve the seller, the buyer, provided that they can ensure that the buyer is of a standard that they would be happy with and meets their criteria and has done the training, etc. And that is all very fair and reasonable, but make sure that that is as far as it goes and that the franchisor is not unduly or unfairly hampering your ability to make a return. On a similar vein, certainly the British Franchise Association would want to see that there is a provision enabling the business to be handed over to a beneficiary in the event that you as a franchisee pass away. So again, there should be something in your agreement, hopefully, that enables that to happen. And also note termination for breach. Don't be too frightened by the termination provisions. They are going to look really tough and they can be quite scary. But as I said at the top, it's quite important from your point of view that you know that your franchisor has got the right, not so much to terminate you, but to terminate any other franchisee in the system who might be letting you down. So, legal advice. Here's a question that we're often asked. I've been told that the agreement is non-negotiable, so why should I bother to get a lawyer to approve or to review it for me? Because it's not going to make any difference. Now, that, as far as it goes, is true. Most agreements are presented as being non-negotiable, and franchisors are very reluctant to make changes. However, from your point of view, bearing in mind the amount of money that you're potentially investing in your franchise, I think it is very important to make sure that you understand what your agreement says. If you get a review and report done by a BFA affiliated lawyer, they will tell you whether your agreement is standard or whether there are things in it that are particularly difficult or really unduly onerous or just not workable in practice, whether there are things in the agreement that are really inadequate. Your affiliated lawyer ought to check the trademark position that I mentioned at the top, and they ought to make sure that you comfortably understand the liabilities that you're taking on. Note that some of these liabilities are not just applying to you during the term of your franchise, but will actually go on applying after your franchise agreement comes to an end, because in all probability there will be non-compete clauses in the agreement, for example, that will prevent you from dealing in a competing business or a similar business maybe for a year after the franchise agreement ends. So you need to make sure that you understand what the implication of that is. And bearing in mind the amount of money that you're spending on investing, I think spending a few £100 getting a lawyer to give you some advice and a report is probably money well spent.